With Ola. This is Mujala Oluwa. I just got back from work, my day job, and I just thought to do this video, which I believe will be very helpful, for young lawyers, especially newbies, as to criminal defense or prosecution. So, at work today, I was discussing something with my colleague. We were discussing a legal advice that she had written, which had been vetted, and it dawned on me that once you know the basics with criminal law, you are good to go. You are home and dry. So I'm doing this video. I'm hoping that I can save this life so that a lot more people will be able to benefit from it. And once you get a hang of what you should be looking for, as a prosecutor or as a defense counsel, criminal litigation is very easy. So I put some things down that I may look at from time to I just got back from work. I thought to do this, so I quickly put some things down, things that I've been thinking about lately. I remember that late last year, early this year, I put out a tweet where I said that criminal cases are open and shut. And a blog or an organization are taking that tweet from Twitter and put it on Instagram. And people in the comment section, lawyers presumably, were saying things like, I don't know what I'm talking about, or I'm probably just new. I don't probably understand, what I'm talking about and all of that. I saw that, a colleague of mine jumped in the comment section. I was correcting people and saying that, oh, she works with me, work together. This is what she has done for so, she's this, she's that. And another colleague, from college was also in the comment section on one of those days when that blog had put my tweets and people were saying all manner of things. I think that it's easy for people to dis your opinion, your informed opinion, when they don't really know you or your antecedent, and that's okay. But we're not here to explain ourselves, our antecedents. We are here to discuss the business of law. And that's what this channel has always been about, and that's what it will always be about. So in this video, in this live session, I did not make any publicity for it. I just thought to do it today, like this evening, and here I am doing it. So if you catch it later, it's not as if maybe I told some people or made an announcement and then we did it behind your back. Especially if you're a loyal member of the channel. So you're just as good as whoever joins live. So we're going to be talking about what you should do or how you should go about prosecution or defense to a crime. And I'm going to be using a few crimes, as examples. If you're a young lawyer, maybe a client has just approached you and they are probably saying that, oh, I've been charged to court for this, I need you to defend me. Or maybe a prosecutor, you work for government in the Department of Public Prosecutions, and your boss has handed you a file and said to you, go write the legal advice. We were discussing a legal advice at work today that my colleague ran by me, and I saw that it was important that for crime, all you need to do is to understand the ingredients of the crime and to understand how the charge has been framed, And once you're able to get your way around that, it's easy for you to do whatever you want to do as a prosecutor or as a defense counsel. Now, I used to be a prosecutor. I'm now chiefly a mediator. Yeah, but I still work for the prosecuting authority anyway, for a while. So let's talk about how to, at the moment, at the time of recording this live anyway. So let's now talk about it. So we're going to be using the crime of rape, we'll use murder, and we'll use conspiracy as instances so that you can understand why I said in that tweet that, criminal matters are open and short. I've done several videos on this channel, and anyone who's followed this channel in these 3 years plus will know and attest to the fact that I have a bias for criminal litigation. I just feel like it's very simple. In Nigeria, it's not that rewarding, financially, but it's very simple if you know what you're doing. And of course, the bottleneck of prolonged litigation affects all cases, criminal cases included. So aside that, it's something that you can easily develop expertise in and that you can really get ahead with as a young lawyer. But how do you go about it? I've done a video on how crimes are prosecuted A to Z. Please watch that video. I've done a video on how to defend a crime. I've done some videos on defenses that are available. to a defendant in a criminal matter. About 3-4 videos I've done on how to prosecute and defend crimes. But today we just want to talk about, I've titled the live criminal prosecution or defense for dummies. It doesn't mean that whoever is watching it is a dummy, that's just a term that's used, that it's simplified, so that you understand the basics. Now, what should you look for if you have a file? Let's say you're a prosecutor or you work in the Department of Public Prosecutions. The way it is done is that if you work there and a file is assigned to you, you would need to, you are the advising officer, you have to write your legal advice in that matter. Then it will be forwarded to a vetting officer who will vet it, and then the Director of Public Prosecutions will then do the final vetting. He or she would probably either agree with you as the vetting officer or as the advising officer, or disagree with both of you, or agree with both of you, agree with one person, disagree with the other people, and with the other person, and then give the directive that the legal advice should be issued. So legal advice could be that the state is not charging, or it could be that the state is charging and this is the offense the state is charging for. So that's basically how legal advice is done. Now, let's say they've given you a case now of, say, conspiracy to issue a legal advice. You know that the police makes the arrest and carries out the investigation in Nigeria, after which they will forward the file to the Office of the Director of Public Prosecutions to advise on it. That office will determine. Now, you are a member of that office and you've been asked to determine if this case is going to court or not. What should you do? You should read the case file. Case files are very enjoyable and very sweet to read. I remember when I used to prosecute, of course I wasn't a lone prosecutor, so I'm not going to take the glory, that's not mine. But I used to enjoy reading new case file because it just gives you an excitement. You're reading the statements, you're reading what the investigating police officers have written down from the investigation they carried out. You're reading statements of witnesses of the accused person or defendants. You're looking through the proof of evidence, you're looking at the list of witnesses and what the witnesses have said in the matter. You're looking at the evidence that you are going to tender, if any. It could be hard evidence, it could be, soft, and whatever. And then you're preparing generally for the matter. And if there's a bail application, you're preparing a counter affidavit, So now you are the prosecutor that's been asked to charge the matter to court. How do you draft the charge? We've done 2 videos on drafting charges or charges in Nigeria. Please watch that as well. What do you do? When you read the case file, you know that before you can charge someone, an offense must have been committed. In Nigeria, you cannot charge retrospectively. That means that you cannot charge if an offense has been committed and the law now comes in place later on, you cannot charge the person based on that law that came later after the offense has been committed. Also in Awoko and Fagbemi, the court has held that you cannot charge an accused person or a defendant for a non-existent crime. So the first thing you want to know is that what has this person done? And this thing they have done, is it codified in any law as an offense with a punishment? Because if it's an offense and there's no punishment section, it's basically not an offense. So what is the punishment section by which we want to charge this person? So then you now look at what has this person done. Okay, they said that this person planned with another person, to go rob so house, and then on their way they were caught by the police. They were caught with maybe they were caught with ammunition or with guns, with machetes or whatever, and then they were arrested, and then they confessed that this is what they were going to do. What is conspiracy? I think I put down the sections. I'm going to be looking at my jotter, for a few things. So I think that conspiracy is section 517 of the Criminal Code. So you look at, you decide under what law do I want to charge this person. You could charge them under the Criminal Code if you're in the southern part of Nigeria. You could charge under the Penal Code now if you are in the northern part of Nigeria. And then you could also decide that I want to charge them under a state law as opposed to a federal law. Criminal Code is a federal law, but states now have their own criminal code. So for instance, the Lagos State Criminal Code Act, the Oyo State Criminal Code Act, the Ogun State Criminal Code Act. You could decide that you want to charge them, under, say, the VAP law, that's the Violence Against Persons Prohibition Act. So the law under which you decide to charge them is very important. After deciding the law, you look at the act that has been committed. Is it codified under any law? Now, these two people were caught and they have confessed that they were going to actually rob a house. Now, you look at what section of law provides for something like this. Section 517 provides for conspiracy under the criminal code. And it basically says that if two people plan to carry out an illegal act, that's conspiracy. Whether they carry out the act successfully or they do not carry it out, once they have planned together, conspired literally to carry out the act, it's already an offense, and that's the offense of conspiracy. If you check most charge sheets in Nigeria, especially in the southern part of Nigeria now, I can only speak for the southern part because that's where I've practiced. There's conspiracy usually is the first charge, and then there's a follow-up offense. So you look at, is there a conspiracy? Two people agreed to go and rob a place. They were caught while they were going. It's an inchoate offense. They have not carried out the act. You know that we've done videos on mens rea and actus reus on this channel as well. Please watch them. Mens rea is a guilty mind. That is, you have thought up a guilty thing, an unlawful thing to do in your heart. Actus reus is you carrying out the overt act of doing that thing. So you have to look at the offense. Is there mens rea? Is there actus reus? These two usually are required for an offense to be before you can say that an offense has been committed in Nigeria. But there are some types of offenses called inchoate offenses, and one of them is conspiracy. Inchoate offenses are offenses that need not have been fully carried out before you can say that an offense has been carried out. Conspiracy is one of them. That means that a guilty mind is sufficient. So these two people actually planned to do this thing. They did not eventually do it because they were caught, but they planned to do it. So there was there's mens rea, but there's no actus reus. So, for instance, the crime of rape as well. If someone tried to rape someone now, maybe the person repelled them by force, and then they were not able to carry out the act. Maybe they had even undressed. Maybe a man tried to rape a lady, and he had undressed and was trying to carry out the act, but the lady fought back, escaped. We may not be able to charge for rape because there are ingredients that must be looked at and complete before the crime of rape can be said to have been occasioned or committed. But we can charge for attempted rape because there was an attempt. Attempt is an inchoate offense. So there was an attempt to actually rape, but it was not fully carried out. So there's a guilty mind present. So now conspiracy, so when you look at if you look at the proof of evidence that the police has forwarded to the office of the DPP, they have said the confessional statements are reviewed, and then the IPO's notes also probably said that at a so time of the night we caught them in this place. They said they were not residents of that place. They were going there to commit an offense. They were going there to rob the place. We found the implements with which they wanted to rob and all of that. So you look at the totality of the evidence of what is in the case file, and then you can decide, okay, conspiracy. Let's charge them for conspiracy. And if a prosecutor that will go to court to try the offense as well, what are you looking at? You're looking at the ingredients of the offense, the proof of evidence that is in the case file that's been given to you. Does it support the charge before you go on a fool's errand? If it does not support the charge, you know that you're just going to carry out, an exercise in futility. But if it supports it, fine. Maybe the implements that were found on them has been forwarded to you by the police, or the IPO has promised to bring them along, and you've listed them as part of the list of exhibits to be tendered. That supports your case. Their testimony, their statements where they have confessed to the crime, that supports the case. In most states in Nigeria, the administration of criminal justice law now requires a video recording of the statement of the defendant or suspect in police custody. So maybe you have that audiovisual recording too, showing that they were not under duress or under torture when they willingly and voluntarily, said to the police that we were going to do this and this and this. That supports, the crime of conspiracy. And then what they were going to do, is it an unlawful act? Because if two people said conspire together to go to church, going to church is not an offense in Nigeria. So that is not conspiracy, even though there's a plan to do something together. But it is not an unlawful act. So you need to look at all the legs of the crime. What they wanted to do. Is it a crime? And can you establish from the totality of the evidence that there's a guilty mind, even if there was no overt act or if the act was not completely carried out? Let's look at the crime of murder. If you watch the video that I did on Shandy and the State, I talked about murder as well. When you look at the crime of murder in Nigeria, I put it here that it's found in section 315. Now I have a colleague that one day I just asked him that where can murder be found? He's older than me at the bar, by a few years, maybe 2. I think about 2 years. Yeah, my senior. And he just told me, he just like randomly just said, check section 315. I was like, the law. Like some people have these things in their head. So if you're here today, you know that murder is in section 315 of the criminal code in Nigeria, which applies to the southern states. So now, for murder, there are certain things that must be present. One, someone must have died. This is one of my favorites because I think it's one of the questions I was asked when I was about to be employed on this job. Someone asked me around that time, whether in the Ministry of Justice or during the panel, someone asked me this question around the time that I got this job. So I always remember it. There must have been a death, occasioned. Someone must have died. That's one. 2 is that the person must have died as a result of the acts of the suspect or the defendant. 3 is that the killing or the act of unlawfully taking the life of that person or causing the death of that person must have been premeditated. And that's what's called malice aforethought. So there must have been malice, For instance, if someone, maybe the police, for instance, they come into a market square where a fight has broken out and they're trying to, calm the fight down. Maybe the fight is not calming down, and then someone shoots into the air. It could, maybe not even the police, maybe someone shoots into the air to calm everybody. Or maybe like in Things Fall Apart, when they went for that burial and they had to do gun salutes, and then Okonkwo now shot and the bullet hit someone. That's not murder because there's no malice aforethought. Okonkwo, when he was leaving his house, he did not plan that I'm going to go and kill someone at this person's burial ceremony. No, they were doing gun salutes, which is a cultural or traditional thing for them. But there was an accidental discharge. Can we call it accidental discharge? Someone was mistakenly hit. So that's not murder. It could be manslaughter, and he was punished, he was banished for it. So that's maybe their way of punishing manslaughter in Things Fall Apart by Chinua Achebe. But what I'm saying is that is not murder because there's no malice, there's no premeditation that the accused person or defendant wanted to kill someone. So now, even if there was premeditation and the person did not die, or the person did not die as a result of the acts of the suspect or defendant, it is still not murder. It could be attempted murder, or it could be any other thing, but it is not murder once the person did not die, the victim, or the victim did not die as a result of the act of, the accused person, the suspect, yes, or defendant. For instance, I think if you do psychology in school, there's a picture they paint, of appearances and reality, where maybe someone pushed someone off the window, and you could see it from afar. Maybe you're standing in the street, you see that someone is throwing someone down from the window, and then when the person dies and they call you, you will say that it's so person that threw this person and killed this person, so that's murder. But it could be in reality that this person was trying to jump to their own death, and the person you saw from the window was trying to retrieve them or pull them back, but they were unable to, and the person fell to their death. So if that can be established, it will not be murder, yeah, it will be suicide, another name. So once these ingredients are not complete, if a prosecutor trying to draft the charge, you look at the evidence that's been given to you before you send another prosecutor that's going to go to trial on a fool's errand. You look at it. Can we say from the totality of evidence in this case file that murder has been carried out? Did somebody die? Did they die as a result of the act of the suspect? And was there malice aforethought or premeditation? So you can read more on this. And if let's say rape, for instance, if you check, I think rape is in section 357 and 358 of the Criminal Code, and it's also in section 1 of the Violence Against Persons Prohibition Act. I wrote a paper on an opinion piece now, reviewing the Violence Against Persons Prohibition Act in Nigeria in 2020. I might link it if there's a place for me to link in the live caption or description box. Please read that piece. And in that piece, I talked about rape and the innovation that the VAP law has brought. You know that ordinarily, if you check the Criminal Code, the sections I've mentioned, it talks about for rape to occur, it must be that there has been an unlawful carnal knowledge of another person by someone, and there was penetration. Usually or typically, it is the penis penetrating, the vagina, maybe. And in some decided cases, it's been held that once the penis just touches the labia majora, penetration has occurred already. So we can say that there's rape, and then there must be lack of consent. So it could be that the person said no outright, or the consent was obtained under duress, under threat of harm, or intimidation, or impersonation. For instance, a man impersonating the husband of another woman, and then having carnal knowledge of that woman. That would be rape, because the person has been deceived into thinking that a different person is the person they're having sex with. And then it could be fraudulent representation. It could be any other means that is not lawful and that is not clear. Once the consent is unduly obtained or is not unequivocal, we may be able to ascertain or prove rape. So what are the important elements of rape? Unlawful carnal knowledge, which is evidenced by penetration and lack of consent. Those are the most important things that you look for. Now, if the victim is an underage, we already know that a minor cannot give consent. So that's straight. You don't go looking for what is not law, saying, was the consent obtained by force, under duress, did this person willingly consent? There is no consent to be given by a minor. So you just go straight to the other ingredients. Was there penetration? Then you can say this is rape. Now, the VAP law went further to say that it's not just the penis touching the labia majora. If once any part of one person's body penetrates the other person's anus, mouth, or vagina, that is rape. So a man can rape a woman can rape a man under the VAP law, Violence Against Persons Prohibition law. So if you are a prosecutor, what are you looking for in drafting your charge? From the totality of evidence forwarded to the Department of Public Prosecution by the police, was there penetration and was there consent? For you to determine if there's been unlawful carnal knowledge, then under what law are you charging? You know that if you charge under the Criminal Code, it's limited. But if you charge the person under the VAP law, or if there's a state law that is more encompassing or that serves your purpose, you charge under that law. That way, when the prosecutor that will be assigned that file, or that is in the court where the file will go to, is trying the matter, they will not be going on a fool's errand, So it's very important to look at this thing. So what if you are a defense counsel? Very simple. Once you get your client comes to you, or maybe the people of your client, and say that, oh, he's in custody, he was charged with rape. You go to the custody and interview your client. Ordinarily, when your client is arrested, you should be present when the client is making their statement. But some laws, some states ACJA laws, Administration of Criminal Justice law, do not make it mandatory for a lawyer to be present. They say that if the suspect wants his lawyer to be present, even the recording, the audiovisual recording, some states say may It may be recorded or not. And we know what the Nigerian police will do. When you say they may do something, of course, that's a blank check for them to do as they please. But that's not why we're here today. So if you're the defense counsel, you go interview your clients. Did you do this thing? What happened? Where were you on this day? What can you say? So if the prosecution or prosecutor will be able to sustain the charge at trial. Also, from interviewing your client, you'll be able to decide if you have any defense that you want to go to. There are some absolute defenses and there are some defenses that are not absolute. For instance, if your client has an alibi, that's straightforward. For instance, if your client says that, okay, they said that, you look at the charge sheet. Because you're the defense counsel, the prosecution would have filed it before you come into the picture. So you're supposed to be served a charge sheet, or when you obtain it by any means, because sometimes prosecution won't serve you. You have to run after them and get your own copy, or maybe make a copy from the court file. So when you now get, ordinarily you should serve the defendant, who will then, get through to their lawyer. But whatever the case, when you get the charge, you look at it. What have they said? That you on so date, on or at about so hours, had unlawful carnal knowledge of this person, female or male, age so blah blah blah. When you look at it, then you look at the statement of the victim, look at the statements of witnesses, look at what the IPO has said. Just look at everything available to you. There are some things that will just be in the prosecution's file that will not be attached to the charge sheet. But you look at the evidence that the prosecution says that they want to rely on. They are mandated to make that available to you, because it's constitutional for you to be availed with all the facilities necessary for you to prepare your defense. So you look at what they have given you, the statements attached to the charge sheets, the list of witnesses that they are bringing, and how those witnesses are connected to the matter, what each witness has said. Then you look at the list of exhibits, if any. Maybe they have the pants of the victim, or maybe they have the trousers of your client recovered from the scene of crime or something. Or maybe they even have witnesses who are saying that your client has done this, has threatened to do this, or whatever. You look at everything. Can he sustain this charge? Will they be able to prove that there was penetration? If you can see from the evidence that they will not be able, you latch on to that. That's your first armory to pull down the case at trial. Okay, now you look at consent. How old is the victim? If the victim is underage, you know that consent is already out of the question, because a minor cannot give consent. But if the victim is of age, now you look at it. What are they saying about consent? Are they saying it was fraudulently obtained, or by misrepresentation? Or are they saying that maybe your client spiked the victim's drink, or forced himself on the victim? What are they saying about consent? So what if your client and the victim are boyfriend, girlfriend, and maybe things just went south, and things went south. Oh dear God, things went south, and then someone decided, I'll punish you. So you look at all the things, you interview your client. What kind of relationship did you have with this person before? Have you done something like this before? This person, are they even connected to you? Have you seen them before? So you can be able to determine if maybe they're just trying to punish them. Some people do that. Or if it's actually real. Did you actually commit this crime? Because if you can ascertain from your client that he actually did this, what you'll be looking at is, can the prosecution sustain or prove it? Which is not the best, because if you have conscience, you should be looking at mitigating the sentence by looking for, something to, something what you would latch on to, just to help your client get a lesser sentence, if you can confirm that they did it, of course. But then going back to defenses, you look at the defenses. Maybe your client who is being accused of raping somebody at Bodija Market on the 22nd of November, maybe at the hour of 8 p.m. Maybe at the hour of 8 p.m. on the 22nd of November, your client was in Maitama, Abuja, and he was with friends. Maybe he even took pictures and posted it on Instagram. That is your defense. Your client has an alibi. So you want to know, when you come to trial, did the police investigate this alibi? even if they did not investigate it, you do your investigation and bring proof to the court that this is my client, this is the Instagram post, and it's not been doctored or tampered with. And then you bring witnesses, people they were with, who can testify to the fact that we were at so club or so church praying at this hour, on that particular day. And of course, you'll be able to examine that it's geographically impossible for your client who was at Maitama, Abuja, in a church praying by 8 p.m. to have been the same person in Bodija, Ibadan, committing the alleged offense of rape. Alibi, in all of it, insanity. Maybe your client is known for temporary bouts of insanity where he does things that are beyond his own reasoning or control. If that's what you want to bring in and you can prove it, whether medically, or psychologically, you bring proof to court. Then there's provocation, maybe murder, maybe the charge is murder. We know what murder entails: malice aforethought, premeditation of harm, that you actually want to kill the person and then you actually carried out the act and the person died as a result of that act. So you want to tell the court, oh, there was no premeditation. My Lord, my client does not even know this person before, has never met him. How could they have thought up, a sinister plan to kill this person that they do not even know? So you have that. So many things are available to you. So you look at what law has this person been charged under. You look at the law. What if it's a non-existent law or a law that was made after your client was allegedly accused or your client was alleged or accused or your client committed the offense? Or maybe when what am I trying to say? Oh my goodness, I've had a long day. Okay, what if from what the prosecution has put before the court, it is clear that this law was made after your client committed the act? Then that law cannot be retroactive. No, the law does not look back, it looks forward. Now, what if that law is not even existent or does not apply? For instance, if your client has been charged under the penal code in the South, no prosecutor will do that anyway. But that's your easy way out to throw out the case. So if they want to come back, they should go and assemble and bring your client under the proper law. So many things you can do. That's why I said that criminal litigation is open and shut. Of course, you have to battle the vagaries of unending litigation in Nigeria due to several adjournments and things beyond your control. If you are a prosecutor, sometimes it will be difficult to tie down the IPO to come and give you testimony. Sometimes the court will not sit. Sometimes the defense will not be ready. Sometimes even the prosecutor will not be ready to go on because they cannot live with their witnesses. So many things can go on. But aside that, the important work of a lawyer as a prosecutor or as a defense counsel is to look at the proof of evidence. From there, that proof of evidence. And proof of evidence is basically what the investigation that the police has carried out, the witness or that the police have carried out now, using police plural, the things that witnesses have said in the matter, the exhibits available that support or go against the grain of the offense, the law, under what law is the offense being charged, what are the ingredients of that law, and can they be sustained at trial? Those are the things you look at before you can say that, oh, we're going to win this case, or this this charge can be sustained, so that you do not waste the court's time. And if you are the defense counsel too, so that you do not waste your own time, you do not go on a fool's errand, and so that you'll be able to advise your client properly. If it turns out that the prosecution can sustain the charge, are you going to look at mitigating the sentence? That's maybe pleading for leniency before the court, or what defense are you going to rely on? What if you find out that the prosecution cannot prove their case? You can rely on the case of prosecution when it's time for you to enter your defense. You can enter a no case submission telling the court that the prosecution has no case from what they have done so far, and the court will either agree with you or ask you to enter your defense. You can bring your own witnesses to corroborate or to testify in proof of the innocence of your client. You can attempt character evidence. It is weak, but it can work in some instances. So many things can be done, but the most important thing is to look at the law under which the offense has been, the charge has been brought, to look at the time, the victim, and what has been, the suspect is accused of having done, you know, and the ingredients of that crime, if they are complete and if they can be proven, you know, in a trial. So these are some of the things that you look at, you know, as of first instance, whether you're a prosecutor or a defense counsel. And these are the things that I really just wanted to share, especially the ingredient parts. You know, if the ingredients are not complete, you don't need to go on a full errand and waste the time of the court. There are so many matters that the police is forwarding to the office of the DPP that have no substance. You know, I read a case file the other day and I was like, why? What are they trying to achieve by bringing this? So people will think that, oh, maybe the DPP's office, they are not working, not knowing that sometimes the police are bringing cases that are dead on arrival, and an officer will have to look at it and actually charge or decide that we're not charging, which is, you know, time and resources expended. And also, if defense counsel, sometimes too, these things are so easy. When you look at the evidence, if they cannot prove it, then go for that, or go for a defense, you know, to the crime, or rely on their case if you think their case is very weak and cannot be sustained. So many things you can do, you know. But criminal litigation is easier than you may have thought, especially if you're new week. Of course, they say that it's very easy to use mouth to draw some patterns and some maps. So it's not just by mouth talk. But I hope that you will factor these things that I've said into your cases going forward, either as a prosecutor or a defense counsel. And I will always see you in my very next video. Don't forget to subscribe. Leave me comments in the comment section. Toodles.